Today on Off the Clock, we're going to be talking about all things terminations. We're going to talk about how to make the decision, how to deliver that information to the impacted employee, and everything else that is on your minds regarding termination decisions.
Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice. We have talked for quite a while about doing an episode on terminations, and I feel like both of us, each time it's come up, have sort of thought, I don't know, it's not a very fun topic, right?
Well, it is unpleasant when HR has to work through a termination decision and then executing on that decision. So I think much like supervisors who avoid poor performance reviews or termination decisions because it's unpleasant for them as well, it can be unpleasant, right? We tend to have fun on these things, right? And are chipper and upbeat, and it's a little more challenging with this topic because we have to remember the humanity
of it all, for sure, right? And it's certainly not the favorite part of our listeners' jobs, I wouldn't say, but a necessary part. And I really am glad that we're going to talk about it today, because I do think having a plan and having confidence that the way we are making the decisions and executing the decisions is really important and helping to HR professionals and our listeners. So yay for us for doing it, right? And I think we've got some good information.
Yes. So hopefully with a good, solid process in place, right? When termination decisions have to be made and then communicated to the impacted employee, everyone can take a deep breath, say we have a process for that, we know how we're going to do it, right? And then just follow the process. So let's just start at the beginning. One of the things we love about process is there's a beginning, middle, and end. Right? So it's not just everything swirling. So the beginning of the process is the decision itself.
Right.
And
when is the right time?
When is the right time? Should we start there just because of what's happening right now? It's the holidays.
Oh, yes.
Right? I mean, that is, let's face it, I mean, that's not really part of the... well, it is. Are we going to make the decision to terminate now, this time of year? We both get this all the time, right? And this isn't really a legal question.
I was going to say, they didn't cover that in law school. Should you
let's
separate
get that out of
somebody's
the way.
employment during the holidays?
There is nothing illegal about separating someone from employment during the holiday season.
Yes.
Okay, let's just say that out loud, yet people still call us, right, and ask for our advice on that.
Right.
I have never asked you this question. I don't know what advice you give clients. What is your advice when you get that question?
Well, speaking of humanity, right, there is certainly an emotional component to somebody losing their job around the holidays. The holidays are supposed to generally be a happy time, a time to get together with family, etc.
A time to spend a lot of money on gifts.
A time to spend a lot
let's
of
just
money
say that
on
out
gifts.
loud.
That's exactly right. So I would imagine it would be extremely difficult to lose your job right at the same time as the holidays. So I would never go out of my way to recommend that a client make that decision. At the same time, though, for me, it depends largely on the why, right?
Yep.
So I also, I've got to balance that with the fact that I also don't love if we've decided that this relationship is not to be, right? And or somebody has done something that's serious or significant enough that their employment has to end. I also don't love the idea of keeping them employed for 3 or 4 more weeks.
I agree. I almost always like
it depends on the why, right?
Yes.
If we've done, for example, if we've done an investigation because somebody's made a complaint of, let's just say, racial harassment in the workplace, right? And the investigation concludes that that employee did, in fact, engage in conduct that violates our policy and is serious enough to warrant the end of their employment. I would not recommend an employer decide to delay that decision for a significant period of time.
Right.
If instead it's a job performance issue and this has been ongoing and the question is, do we talk to them the week before the holidays or wait until after the new year to talk to them, then I would say that employer has more room to make the decision that feels more in line with their culture as an organization.
I agree completely. My only yes and is I would, if we're getting into December, right, particularly mid-December, and that is our inclination, unless it's a serious misconduct matter, to wait to deliver that information until after the new year, I would consider wait to have the decision-making meeting until after the new year too. I don't like a decision being made and then a long gap between that and the communication with the employee. It leads to all kinds of awkwardness.
Interesting.
And usually, frankly, backfires in some kind of way. And then we have to say, well, we actually already made the decision. That's not why we're firing. We decided to fire you 2 weeks ago, but we didn't tell you. So if you're going to wait. Right? Okay. And have the meeting with the supervisor on January 2nd. Okay, so now let's get back at it. The decision itself, regardless of whether we're making the decision in December or in January, what are the basic components of a solid termination decision? The why. When you're meeting with a supervisor and we're not sure, the supervisor comes and says, I'm not sure if termination's right or not, here's what's going on. What are the things we're thinking about? We're thinking about, one, is there an objective basis upon which to end this employment relationship?
Hopefully documented in some way.
But documented.
We've been around the block a few times, so our expectations are realistic in that way. So minimally an objective basis, right?
Yes. Hopefully
there's some documentation to support it.
Documentation. Think about whether the supervisor's word is good enough for you, or whether you need to ask others, because one supervisor's saying this person is this or that. If something seems a little off, think about doing not a full-on investigation, but a little more exploration to make sure that the facts are as you believe them to be, or as they have been originally presented to you. So number one, is there an objective reason? Number two, how have we treated similar employees in similar circumstances? Have we ended their employment for similar infractions, performance issues, etc., or have we not? Because you can have the best reason in the world, right? But if you're not firing other people for doing the same thing, you're still are putting yourself at legal risk.
Yeah, unless there's a why. I mean, the next question is, okay, well, why then? What's the difference in this situation than in the past one? So I know we probably have some listeners who are going to ask this question. And I know that because I get this question a lot. And I think you know what I'm going to say, which is...
It's another why.
Yes. Why does, if this employee is an at-will employee, why do I need to worry so much about whether there's an objective reason and whether it's documented and whether it's consistent with what we've done for others? How do you answer that question, Rebecca, when you get asked that question?
Well, there's a few reasons I think it's important. Different people may have different advice on this, but I think it's important for a few reasons. First, culture, right? You don't want to have a culture where people just get fired for wearing orange one day or wearing stripes, right? I mean, that would be horrendous.
I definitely don't want to have that culture right now, yes.
It would be horrendous to have a culture where employees did not know when they walked into work every day whether they were getting fired or not, right? It's important to have a culture where people believe that those decisions will be fair, right, and justified when they happen, right? So culture is very important. The other part is, I'll get into the law, right? Legal risk, because we are lawyers, after all.
And the law matters, right?
When you don't have a reason, others will fill in that reason for you and against you.
Yeah.
Right?
Yep.
And so if you don't have a good reason that is based on objective information and is fair, when we look at how this person is being treated to others, if you are challenged on that after the fact, you'll probably lose because those are the two things we need to prove in litigation.
That's exactly right. And you and I litigate a fair amount, right? So for our listeners, yes, at-will employment exists in in Michigan and elsewhere, unless, of course, an employee has an employment agreement or is part of a collective bargaining agreement. That's not our focus today.
Nope.
However, every one of us falls into some sort of legally protected class one way or another.
Because there's reverse discrimination.
Every human being does. And so every individual has the ability to challenge a discharge decision after the fact. Correct. And say, I believe it was discriminatory. Even if I believe it was discriminatory because I'm a white man under the age of 40 without a disability and I'm straight, those. Right? We get those. We get those. So to your point, from a very practical legal standpoint, if our interest is to protect the organization against risk, against exposure, then the best practice is to make sure we have our defense ready.
Yes.
In the event that somebody makes that claim. Because it happens. We have jobs because of it, right? Right? Lots of people believe that their employment ended for discriminatory reasons when in fact that's not true.
Right. And so let me just do a yes and. Not only will making a termination decision based on objective information and fairness compared to similarly situated people help you win the lawsuit and may help you avoid the lawsuit. Yes. When you communicate those things to the employee, when we're telling them the whys, if a little bit of it resonates with them as true, they will be less likely to bring a lawsuit in the first place.
We have seen that live out.
If they think you're making decisions, right, just willy-nilly, even if they don't actually believe it's discrimination, it will seem so unfair to them.
Yeah.
Right, that they will get very angry and seek legal counsel, and that lawyer will come up with something.
Yeah.
Right? Because that's what lawyers do.
Yeah.
Okay. Let's move on from the decision then. Let's assume there's been a decision-making process that is sound, that is documented, that is based on objective information, and that is fair as we compare employees to each other. The next thing employers need to think about, not necessarily do, but think about, is do we want to offer a separation agreement?
Right.
Right? What do you think about that? How do you respond to clients who ask about that?
It often depends on the level of risk aversion of that organization, just out of the gate, right? If this is an organization that doesn't tolerate the risk of any claim, right? Doesn't want to waste any time and money, and also has no problem with giving somebody something on their way out the door, even if that person may have broken our rules, broken our policies, not been a great employee, their job performance may not have been great, then I have no problem with routinely offering separation agreements. But that's not every organization. So I first want to know, okay, who are you guys, right? And does this make sense? I will add too, there are different aspects to there are different levels of what we can give an employee in return for a release of claims in a separation agreement.
Sure.
We don't have to give them a significant severance, for example. We can agree to allow them to resign. We can agree not to contest their unemployment benefits. We can agree to pay them their vacation time or paid time off if they wouldn't otherwise have received it. Sometimes employees owe us signing bonuses and other money. We can agree that we're not going to make them pay us back, etc. So there's a lot of options out there.
Right. Yep. That gives you the upside of the separation agreement.
Yes.
Then, right?
And let's be clear, the point of the separation agreement from the business's standpoint is to get a release of claims, often an agreement regarding non-disparagement.
Yes. Let's just pause on that for just a moment, right? Yeah. That can be huge, right? Yes. Huge. To get a non-disparagement, non-defamation if it's a non-supervisory employee, because that's a separate podcast, but the NLRB has had something to say about that. But yes, you can get employees to agree to things, other than just the
Yes.
waiver of claims,
Yes.
right? In these separation agreements, as long as we offer them something of value.
Return property.
Right.
Some employees have valuable property that we really need back, and so there's some strategy to that. I mean, my experience is that most employers take the separation agreement option on a case-by-case basis. I don't see a lot of employers that give it to everyone as a matter of practice or policy on their way out the door in every circumstance.
Right.
And I also don't see many employers that are 100% opposed to the idea under any circumstance, right? It's usually case by case.
Right. I agree. One of the other advantages of the separation agreement for employees, again, on a case-by-case basis, who you may be concerned about disparaging you or engaging, let's just say, in bad behavior or damaging behavior towards your organization, is you can arrange separation pay payments, severance pay payments over a period of time.
Right.
And the money stops immediately, right, if they misbehave, for lack of a better phrase, right? So it gives you some level of control post-employment.
That's right.
Right, if you're worried about that.
And yes, to let the dust settle more or less, right? I do think that there's, when somebody loses their job, sometimes that time of anger and the proclivity to lash out is within a certain period of time after, and then they begin to move on.
Right, I completely agree.
To other things,
So before we move on from separation agreements, as organizations, after they make the termination decision, then they're saying, do we offer a severance or not? Just remember there are differences in the actual agreements based on whether someone is a supervisory employee or not, and based on whether someone is under 40 or 40 and over, and based on whether more than one person is being separated at the same time. So we're not going to get into this isn't just a separation agreement episode, but just keep I just want people to keep those things in mind, right? So if they just keep taking the same one out over and over, just remember.
Yes, right.
Yeah.
And yes, and from me. One of them is the thing that I come back to almost every episode, and that's state law. Some states have additional things we have to include in separation agreements by law. And also, it's critical to look at whether there's any other agreement in place with that employee. So sometimes employees will have signed a confidentiality agreement or a contractual part of a handbook.
Yes.
And we need to make sure the separation agreement doesn't override those things, because we would want both to continue to be in place.
And a lot of form agreements that you may get
Say
online
that
or from your buddy or whatever.
agreement.
There's something called a merger clause, which says this agreement wipes out every other agreement.
Exactly.
So you don't want to do that, right? Particularly if there's a non-compete or confidentiality, things like that.
Thanks for watching. The conversation on terminations will continue with the next episode.